Okay, so hi, John. This is Rebecca Kosas here from CHEA, California, and I want to introduce you to our newest board member, John McGowan. John McGowan is our vice president. How you doing?
I'm good, Rebecca. How are you?
Oh, good, very good. It's a beautiful day
It
outside.
is.
We're inside in front of our computers.
That's right, but it's good to see you.
Yeah, good to see you too. And thanks for being willing to jump in and join me here at the last moment at just a few hours notice. So I wanted to talk a little bit about these fake rights that have been of concern to us, and I think others as well in the homeschool community. There was the Sixth Circuit Court decision that created or had the potential to change the landscape for home educators across the country. It wasn't just a local or a state issue. Can you talk a little bit about that and just explain what happened and why it was of a concern to us?
Sure, I'd be happy to. And keep in mind, this comes right on the heels. I think we all have this fresh in our minds of the Harvard magazine article that Harvard professor Barthollet wrote. Really, if you recall that article, she basically implores the courts to get involved and laments having to deal with the different legislatures and homeschool families' influence over their lawmakers. And she makes a point that, again, if you remember, she's calling for a presumptive ban in homeschooling in all 50 states.
Mm-hmm.
And she says, I think the way that we're going to have to go about getting there is through the courts. And, lo and behold, a few weeks later, the Sixth Circuit, which sits in Michigan, Ohio, Kentucky, and Tennessee, there was a case pending there brought by a number of students in attending Detroit public schools, which, the students, I think, their case is certainly sympathetic. The public school system in Detroit has no shortage of problems. They describe it in the court filings as an underfunded, rodent-infested schools in name only. So I certainly have sympathy for, these parents and these students who are attending there. And eventually the case made its way to a 3-judge panel before the Sixth Circuit Court of Appeal. And the judges there also had sympathy for these students, but they went about showing their sympathy in a way that could be damaging, not just for homeschoolers, but for a number of students. And ultimately the court there, the 3-judge panel there, found for the first time ever that there's this brand new constitutional right to a basic fundamental minimum education. So it's kind of a squishy term. They talk about what that means, but by doing that, by finding in the Constitution through the Due Process Clause this right for all students in the United States to have a basic minimum level of education, they've set up the potential for judges, district court judges, courts of appeal all over the country, and ultimately the Supreme Court, to be the deciders over what that looks like. Not the legislature that we're able to go and petition and speak with and influence over and vote for. That's how the Constitution, set things up. We were able to vote for our politicians and the people who are going to make these laws and go petition them and make our case to them. Well, it's going to get taken out of that arena and it's going to be up to a judge somewhere to determine what that means. Undoubtedly, that would end up meaning challenges in federal court, not just in California, but in other places, to the current homeschool statutes and laws in place, and challenges over whether or not those systems that have been in place for many years and working well meet the squishy term of minimal education, basic minimum education, what that means. So we don't want to judge making up new rights that are going to affect our rights to homeschool that are by statute here in California, and we like how they are, and we don't want some judge somewhere else deciding something that we've lobbied for and worked with our legislators for decades to make sure they are what they are.
Mm-hmm. And so here in California, homeschoolers fall under, private home educators fall under private school statute. So this could potentially be a hazard for all private schools, those with a brick and mortar campus, as well as home educators, correct? They could start mandating content or mandating minimum, as we said, minimum requirements that we've specifically left the public school system because we want to establish our own. So it's not just home educators that could be at their rights at peril, but all private schoolers in California, correct?
Yeah, that's a very good point. So it would imagine, there was a lot of turmoil over Common Core for a long time, and love it or hate it or whatever your feelings are about it, it certainly was a point of contention and getting it passed in the many states. Well, this could be a judge, sitting in some court, probably a panel of judges deciding whether a set of curriculum, that Congress establishes for the entire country meets the minimum standards or not. Right now, curriculum, even speaking in public school settings, there's state level curriculum decisions, and then there's still some local level curriculum decisions. Somebody in Washington eventually would be deciding what minimum curriculum standards there would be for every state. And certainly that would not just apply to public school or homeschoolers, but private schools certainly would fall under that too.
Mm-hmm. Okay, so what do you do? So how do you advocate? CHEA is an advocacy organization, and we're big on sending homeschoolers to the Capitol to lobby with their representatives there, and also to their district offices. Obviously, it's not happening right now, but how do we advocate against these types of decisions, and what's the next step?
Yeah, so that's a real important question, and that is what's so problematic. One of the things that I think is so problematic with a ruling like this is that it takes the ability for us to be advocates and to lobby and to have conversations with people making the decisions. Really, it takes it away. When a judge decides that there is a new constitutional right, they've basically removed us from that process, us being the citizens from the process. There's no way to advocate for them to change their mind. I mean, it has to get decided in the courts. Big picture wise, we can always change, there's a way to change the Constitution if we wanted the United States Constitution. That's not practical. That's not going to happen. So setting that aside, there really is no way. So one of the things that has happened, I guess I shouldn't say there's no way completely to be involved, but there's no way for us as private individuals to directly, speak some advocacy into this issue. Now, we can support groups like HSLDA that do have a voice in the courts, and Jim Mason with HSLDA has been involved in this case, and there was a request, a petition after this 3-judge panel ruled the way that they did. The state of Michigan filed a request for the entire Sixth Circuit Court of Appeals to basically rehear the case. You're allowed to do that when only a portion of the court sat and heard the decision, and that's common, and that's what happened here. A 3-judge panel ruled on this. Well, the state of Michigan asked the entire panel to hear it. It's an important issue, they said, and it belongs before the entire panel. We want a rehearing. HSLDA filed an amicus brief, a friend of the court brief, and joined in that request and let the court know why it was important to us as homeschool families that it be reheard. And the court granted that request. So the entire Sixth Circuit Court of Appeals granted the request for a rehearing. So there is going to be a rehearing. They're going to hear the case, and it's going to be decided by the entire, I think there's 18 judges on the panel as a whole, as opposed to the 3-judge draw that we got. So, you know, we can certainly support groups like HSLDA that are able to speak in court and speak to these judges. And really, we as citizens, as people who vote, need to be mindful of what our votes mean. We want judges, federal court judges are appointed, every one of them is appointed by the President of the United States. We want judges who are going to give deference to the Constitution and to you know, not see it as a changing, living, breathing thing that you can read into it. You know, you know, whatever the cause celeb of the day might be. Give deference to the drafters and the language that's there, and so we need to be mindful of what type of president is going to appoint those type of judges. So that's certainly important in what we can do as individuals. If we don't want rogue judges and judges, you know, creating rights out of thin air, that really is the way to do it.
Okay, and I think the framers of the Constitution made it clear that education was not, well, it was specifically to be dealt with in the individual states. It wasn't part of the federal government's job, correct?
Yeah. So we have a federalist system in the United States that the Constitution sets up, and you know, dual sovereignty is a term that sometimes you might read about. And you know, we have the federal government, and then we have the states, the state government, and they don't. Sometimes they share some responsibilities, but often they do not. You know, most of our day-to-day, the things that affect us most are, you know, decided at the state level, and that's because they're the closest to us, and we have the most access to our local and state representatives. And education has always been something that is done at the local level, and that's just part of our federalist system. Absolutely.
Yeah, and I sure appreciate that. So, well, thanks for explaining that. So when do we have, you know, when do we expect to hear a decision? Is there anything looming on the horizon, or is this something that will be months in coming?
It's probably going to be months. I'm not aware of a hearing date. If they set up a new hearing date, I don't think that they have yet. But even if they were to hear this case, you know, in a month or so, they're not going to announce their decision right away. So I would say it's months away.
Months away. Okay. Well, will you let us know if you hear anything?
I will. I'll be monitoring it.
Okay. All right. I appreciate that. Sure. And, you know, and I should have mentioned to everybody who's watching us that John, in addition to being one of CHEA's board members, he's also an attorney. So I feel like he's, you know, especially equipped to be commenting on these matters. So I've been known to email John and say, what does this mean? You know, and he's been very helpful in enlightening me.
Anytime.
I appreciate it. So I want to talk a little bit before I let you go about, you know, the CDC has made their guidelines for schools opening public, and I think they collected them all in one place and published them a couple of days ago. Homeschoolers and homeschool leaders in California, you know, are really wondering, how is this going to apply to us? What does this look like for our homeschool groups? Of course, parents across the land are very concerned about the impact it will have on their children. But I'm thinking about us in California right now and how it affects our landscape. How will groups meet? How do they know what they can and can't do?
Yeah, so that's a good question. It actually dovetails nicely on really what we were just talking about as far as federalism and you know, who sets the rules in our day-to-day lives. You know, the CDC issues guidelines, and that's what they are. They're guidelines, and they could be helpful in many instances, and there's something to look at and consider. But that's really it. That's what they are. They're guidelines to look at. And
Okay.
they are not, we're not, a homeschool group is not somehow bound. It's not a law. Now, what does come into play, depending on where you live in the state, certainly we have state, declarations, during this emergency, and we've got local city and county laws that have been put in place as well relating to the pandemic, and that's what's going to govern what you can do. I would encourage people to know what their county health department has put out, certainly the state as well, but those are what's going to govern right now.
Okay. And those seem to be changing on I don't want to say quite rapid pace, but they are changing, and we can expect those to be changing within the next month or so as we move through phase 2. So public gatherings will be, they look a little different when it's time for homeschool groups to start getting back together again after the summer break.
I hope so. And I think that's likely true. I think that I would imagine, the impact on homeschool families is going to be much lighter, if anything, than what some of the school districts are doing or going to end up doing in public schools. So I don't see, again, we'll monitor it and certainly keep an eye on it, but I don't think the impact that we end up feeling is going to be too harsh, if anything. And you're right, it is changing. It's changing. I think it is changing weekly, if not daily. And the trend certainly is to lighten the restrictions. So we'll keep an eye on that.
Okay, that's wonderful. And just to remind anybody who is new to homeschooling that's watching us right now, private homeschoolers are not subject to the local school district's jurisdiction. So that's why we're saying we need to look to your local, your city and your county, and also the state directives. So as you said, we will not be impacted as heavily as students that are falling under the jurisdiction of the local school district. So, okay, well, thank you so much, John. I appreciate your time, and I hope that I know that this has been very helpful for those that are tuning in and coming, and hopefully they'll come back and watch a little bit more later. And with that, I should let you go. Enjoy your Memorial Day weekend with your family.
Thank you, Rebecca. That was fun. You too. Have a great weekend.
All right, thanks. You too. And with that, we are signing off.